Hi everyone, welcome to the webinar. We're just going to wait a couple of minutes to let more people join. But while we're doing that, just want to give you a quick introduction to Darrow and both Diana, who's joining me on the call, and me. So for those of you who don't already know, we're Darrow. We're an AI research lab for legal ecosystem. We work with a number of players and try and kind of identify legal risk and turn those into kind of actionable insights. Diana, I'll let you introduce yourself first.
Hi, everyone. So my name is Diana Fruchtman. I'm an attorney here in Israel. I've been a legal intelligence analyst here at Darrow in the privacy team for just about 2 years now. Before joining Darrow, I worked in international law with a focus in privacy law, and I have a background in military intelligence, and I'm really happy to be here with all of you today.
Great, thanks, Diana. And so I'm Joe Hughes. I'm a legal consultant in our New York office. I'm an attorney. I work a lot in the privacy space and directly with our attorney partners, dealing with a lot of the things we're going to be talking about today. So on that score, I think everyone's here so we can kind of kick it off. So what we're talking about today is kind of ECPA, which is the Federal Wiretap Act, as it's also known, and it's one of the key causes of action that a lot of online privacy cases work under. We've spoken about it a lot before, and what we're seeing is that it's becoming a more and more common cause of action in the kind of cases we deal with. And the important part about it is because it's federal, it's 50 state, but there's this really interesting nuance, and then I'll turn it over to Diana to see what you think about it. But it's usually not a two-party consent; it's a one-party consent statute, except if there's a crime or tort that is being committed through the interception. So I think at a big picture, what we've been seeing a lot are healthcare cases, and that's been sort of the leading front. So, Diana, like, can you speak a little bit about like why healthcare? Like, what does that have to do with HIPAA? Or
Yeah,
sorry,
absolutely.
HIPAA.
Yeah, so HIPAA, ECPA has been sort of a popular, I guess, trend in cases, and I think there are a lot of reasons for that. One of the major reasons, in my opinion, is that like the legal world sometimes works as a flashlight, right? So you see exactly what's under the flashlight, and that's to say you know exactly where to look. Like you know what websites you're looking for that might violate HIPAA. You know what a violation would be. You know your case law, and then everything that's not directly under the flashlight kind of isn't seen. And so that's one of the reasons why we see a lot of medical cases. And then in addition, I think it just makes sense that it's a serious violation of privacy, that someone's medical information is transmitted to third parties without their consent. I think it just makes sense, like intuitively to all of us, that that's something that we want to stop, that that's a serious violation of privacy. So that I think is one of the reasons that we see a lot of HIPAA related ECPA cases. Does that make
Right.
sense?
Yeah, and to zoom in a little bit. So like a typical use case or a case we would see is where a website, like a medical website, like a hospital website, medical provider, I think, you can think more broadly, anyone who kind of handles HIPAA data,
Mm-hmm.
they're using third-party trackers on their website, and those are taking transmissions that are in violation of HIPAA. Now, why is for ECPA specifically, and I think I kind of touched on it, but like, why is it so important that we have that HIPAA component? Isn't just a wiretap enough to kind of bring the case?
Yeah, well, I think as you touched on before, it's two-party consent, or sorry, it's one-party consent. So you have to have that additional crime tort violation that HIPAA sort of helps us upgrade, if you will, the ECPA into a violation. So without that, HIPAA doesn't really assist us in creating a case.
Right. And now this is like a very familiar line of cases. I think what we kind of wanted to focus here today is like, how does it go broader? Like, what's beyond health? And then maybe specifically touch on these financial cases. So, I'll kind of use that as an introduction to kind of say like, outside of HIPAA, like what are the other crime torts and like fact patterns we're seeing? And how does that get us to like financial institutions?
Yeah, okay. So I think when we're looking at crime tort exception, we need to look at different laws that have that. They can assist us in creating these ECPA cases. So one thing that we're seeing and that I think is a really interesting developing space is FERPA, which deals with education related information. We have COPA that deals with information relating to minors. And then another space that I'm really interested in is the GLBA, which deals with financial products and services.
Right. And so I think that's kind of one of the things we wanted to focus on. So can you talk a little bit about like what the GLBA is? It's I always get this little the Graham Leach Bliley
Yeah,
Act.
I always
Uh,
want to call it GBLA, but I think it's the GLBA.
I think it's GLBA. No, but could you just like kind of give like so we know I think people are pretty familiar with HIPAA, right? Like medical information is protected. Why is GLBA a good comp?
So the GLBA protects financial information that a user submits to a GLBA regulated site, and that just sort of in parentheses is really easy to know whether the institution is going to be regulated because they'll say it on their site. So it relates to financial products and services. So one of the reasons that I think it's really comparable to HIPAA is that when you enter your financial information, say you apply for a mortgage at a big bank, you're entering a lot of information that's very personal to you. So information that identifies you, such as your address, your email, your birthday, your social security, and then information that says a lot about you, right? What your credit score is, how much your debt amount, what the mortgage that you're applying for is, have you declared bankruptcy? All of that is really personal and really says a lot sort of about you. And then the damage that that can do if that's shared with third parties without your consent, is really something that can sort of follow you around and affect you similarly to health information, I think.
Right. And, you know, this is not new. We've seen like these cases coming through. I think like part of the reason of this webinar, why we want to talk about it, is we've seen a big increase in those cases being filed. And, you know, something I wanted, one observation I have is it seems like it's a little more difficult for the courts to get their head around financial information versus
Yeah.
medical information is maybe more intuitive. So, you know, when you're thinking about kind of the cases that are where there's a strong violation versus a weaker violation, you threw out some categories of data. Could you
Mhm.
dig a little deeper into that? Like what are the ones that really like you think are actionable?
Yeah. I mean, I think, well, first of all, to sort of touch on your earlier point, I think it's a little bit of the flashlight metaphor, right? Like courts might be used to seeing, find a doctor, here's a location of a hospital, this is a procedure I searched for, where financial information might be newer to them. And so it's a little bit of an adjustment. But information that I think, when I see it, I think this is a really serious violation is any sort of information that really is going to say a lot about my financial situation. So if a third party without my knowledge is collecting information that's going to identify me, such as my email, my name, my address, my zip code, things like that, and then that's also sort of submitted as well as information about my financial situation. Legal status is often transmitted. So, like, if I'm married, if I served in the military, am I bankrupt? Occasionally, we'll see immigration information, which is really interesting. Things like that can be very damaging to a person if certain trackers are sort of following you around and know how to target you for loans, for debt relief solutions. And I think that can create a really compelling narrative as to why this is a serious violation of privacy. Does that make sense?
Yeah, that makes sense. And I think it may be, a good moment to pause to say, like, what are the kind of defendants who we're seeing in these cases? Because it seems like it's a lot of like loan type companies and, not necessarily just banks. I think everyone can understand if your bank was transmitting data out of your like kind of paywalled account, that would be like of an egregious violation and very like easy to understand. But I think when I look at the case law and what we're seeing is it's a lot of like loan processors, mortgage companies, and maybe alternative financial services companies. Is
Yeah.
that like consistent with kind of how you're looking at this?
Yeah, I agree with you. I think, one thing, first of all, it's important to note that the GLBA protects not only those who are actual customers, so say I'm, customer at the bank, but even if I apply or fill out my information, that activity is covered under the GLBA. So that's an important thing to note. And then on top of that, yeah, we do see a lot of sort of smaller loan vendors, quick debt relief, get out of bankruptcy for free sort of a trend because these websites, I think, there's something sort of, I don't want to say predatory, but it's very get out of bankruptcy free sort of a situation. And then you're going to put in a lot of really personal information. So even though you may not yet be a customer and you're sort of within that funnel of hopefully from the website's perspective, from the company's perspective, joining or applying, that information is still going to say just as much about you as if you were a customer.
Yeah, no, I think that's a really great point because, and it goes back to what we are talking about, the sensitivity of the data,
Mm-hmm.
because there are situations, right, where we'll see trackers that are taking form field data directly out. The customer inputs information about themselves, their credit score, why they need the loan or debt consolidation or something like that, and that's transmitted to a third party tracker, for example, like a Google or a Facebook or something like that. Like it's a common fact pattern. But I think what you just touched on is something interesting, that in almost all of these cases, there are plausible allegations that the fact that you are seeking this type of financial support is not something you would want publicly advertised or used to target you for greater advertising. So is it safe to say that when we see these trackers, like on a technical basis,
Mm-hmm.
there's a base level where you're always capturing like the some level of website activity?
Yeah, I think it's true to say that there's going to be some level that's captured, but not, there's different levels in my mind in the way I sort of categorize it of violations, right? Because if you log onto the website, that in itself could be a violation, like you said. But I think the more severe violation is going to be when the information that you've entered, for example, I wouldn't want my credit score being transmitted to TikTok or to Facebook or to Google. What they could do with that is interesting, but not something that I would like to personally experience. So we do sort of categorize within like our creation of cases what would be a more severe violation of privacy. And that sort of touches on your earlier point of creating a narrative for the courts that says this is as severe as a HIPAA violation.
Yeah, and helping the courts understand why these violations are severe. I
Mm-hmm.
mean, I think there's been a lot of activity in the financial data breach side, and I
Yeah.
think that is very much tied to risks of identity theft in terms of understanding the sensitivity and sort of the data breach framework. But, correct me if I'm wrong, but like when the big third parties are taking this data, they're using it for commercial purposes to target you, but that's still, a privacy violation in the rules and kind of how we think about the tracking and surveillance and targeted advertisement, a way of thinking of that. Would you kind of agree?
Yeah, absolutely. I would definitely agree. I mean, I think it's very within the lines of what the GLBA is and why it was created and what it's meant to protect. So I think it's well within the parameters of the law. And I think, I find it helpful to think about, like you said, one of the things that we see a lot with these cases are different sort of loan vendors. A loan if you're bankrupt, if you want to adopt a child, that's something that I've really seen, for any purpose. And then what happens is when that follows you around, right? So you're constantly seeing advertisements for get a quick loan, what the interest rate is, no one's going to tell you. And that can do severe damage to someone. If you're constantly seeing that, you're probably more likely to apply for a loan, whether it's in your interest or not. And so that can do financial harm to a person, similarly to data breach.
Yeah, I mean, it's interesting because you don't want to go too hypothetical or kind of speculate, but obviously this commercial advertising infrastructure also leads, like we've seen activity around surveillance pricing. We
Mm-hmm.
obviously know about the very invasive targeted advertising and tracking and profiling claims the courts have been receptive to. So it all sort of feeds into the same place, but it's not medical. But that doesn't mean, in some ways, it's maybe even more valuable to these companies, if you're looking at theories like unjust enrichment and things like that. I did want to dwell a second on GLBA because I kind of want to throw up a little bit of like a disclaimer. Like, it's not, we talked about the ECPA crime tort exception, we've talked about GLBA. Like, that's a very clear way to go into the court and try to make the HIPAA analog.
Mhm.
But my understanding is that is not always how the courts use it. They use it maybe in the Article 3 context to kind of find the sensitivity, this is protected data, and they also find it to frame maybe a negligence per se claim or something like that. So, you know, uh, I guess what I'm kind of is it right to think that ECPA crime tort exception can also just be covered by things like invasion of privacy? Like it's not always a one-to-one basis with GLBA.
Yeah, I think so. I agree with you on that.
Yeah.
Is that something that
Um,
you've seen a lot in cases that you've read?
yeah, I think it's just a caution because I think it's a very good framework to think through these cases. But specifically, there was a case out of SCNY, I believe it was
Mm.
Reach Financial, that the court had trouble making that GLBA to ECPA crime tort exception kind of jump. But I don't,
Yes.
I think if you look at how that the court handled that case, they were like, but there were other things at play. They just weren't brought up in the motion to dismiss briefing. So there are other ways into it, right? But I think the really important point is if you're saying this is protected financial information and you can point to a federal statute, that gives you a lot of ground with the court to like, keep the case alive, build the narrative, and
Mhm.
and support the general idea that which is true that this is like these are severe privacy violations and they can't be sort of brushed away. Um, but we've talked a lot about that. Um, when you're kind of trying to find violations, right, in the world, I mean, there
Mhm.
are thousands, of potential website. I mean, tens of thousands in the United States. On a technical basis, like how do we do that?
Yeah, so I think we sort of touched on this before, but these cases are a bit of a heavier lift technologically because these websites are often just a little bit more advanced than our typical hospital, and so they're not as easy to sort of uncover the violations as a hospital website would be, and they kind of require a bit more. They require some advanced technology, so that's something that we are able to do at Darrow, and then on top of that. We developed a technology here at Darrow that scans thousands of websites and then simulates these user journeys across thousands of websites in a scan. And then that allows me to sort of extract the violation indicators and sort of filter through that and find what I think would indicate the strongest violation. So that cuts down significantly on the time it takes me to find a case, which is incredibly helpful. And that means that we're very efficient in uncovering these violations.
Yeah. And you just raised sort of the difference from hospital websites. And, something we haven't touched on yet really is financial services companies are differently regulated, arguably
Mm-hmm.
more proactively regulated, and the terms and conditions, user agreements, arbitration clauses, like are a much heavier lift.
Yeah.
How do we even approach that issue? Like, what are we looking for?
So yeah, it's interesting. It's something that we have to be very proactive about when we're looking at these financial websites because the terms of use, first of all, these websites always have like 10 different terms of use, right? There's never
Mhm.
one. You have to read through like all of them and go looking for them because when you join any sort of financial company, you sign dozens of terms and agreements. And that's something that we find can be problematic in terms of jurisdiction, choice of law, and significantly, I think, is arbitration. That's something that we do run into a lot. Now, that is something that we have been able to address within our tech. So we're able to sort of quickly filter out or filter in which websites have arbitration clauses, which ones don't, whether we think that arbitration clause could be something that we could work with, or whether it looks like something that we won't be able to sort of work with. So it is something that is kind of a heavier lift legally as well as technologically, but it's something that we're finding ways around.
Yeah, I mean, when I think about that too, I also think about the importance of the customer journey, and tracking that, which I think
Mhm.
is something, correct me if I'm wrong, that is something we we really do, because I think you'll find that if the wiretap has already taken place or the violation or the information has already been transported, and then you are presented with a privacy policy and terms, may not help you so much on the arbitration side, but in terms of like, you didn't give consent to the capture. I mean, is that like a fact pattern we see is just like a basically an insufficient customer journey to get consent?
Yeah, that is something that's pretty common where you fill out, like, you spend 10 minutes filling out a form, and at the very end, in teeny, teeny, tiny font, like underneath the I submit my information, you see like a tiny, like in gray font on a gray background, privacy policy link. And then when you click on the privacy policy, it's 30 pages and they have very conflicting information about what's transmitted and what's collected. And you wouldn't really expect someone to read through this and also understand. And so that's something that I do see quite a lot, that it's very different. The disclosure is different than what is actually happening. And it, of course, the disclosure is at the very end of a form.
Right. I mean, yeah, and I think, from the legal side, courts handle that differently. That's super jurisdictional of what they're going to need in terms of click wrap and, agreeing to the kind of online forms. But, as a kind of, I mean, and I think maybe this is another technical piece. These trackers are not sort of, or at least some of them are dynamic. They are tracking you as you go. They are recording the depth of your progress through the application. They are like capturing the form fields. So you may never even hit submit. You may never agree to anything. And you've already kind of had your information taken.
Right. Like you said, it's kind of jurisdictional, but it's definitely something that we see. And it's frankly, in my opinion, pretty egregious.
Yeah.
So it's,
Yeah, and I think something we kind of touched on, and maybe is like maybe why it's not that big banks and the major financial institutions are not doing these tracking. They just may have solved this part where they're getting,
yeah.
a more ironclad kind of legal process. Which, if that means real consent from the users and informed consent, right, like by a strong cookie banner or something, that would be good. And actually, I did just want to note, are these also cases where we're seeing ineffectual, like cookie reject issues where you're getting the option? Like, is that a possibility in these cases as well?
Definitely a possibility. That's something that we see in a fair amount of the cases where you've got this cookie banner that says we use cookies, and then either you reject the use of cookies and the cookies are still following you around, or they kind of say we use cookies for something that's very unrelated to what the cookies are actually used for. So those are two things that we do see quite often.
Yeah. And, I think also I know, we're just seeing more of these being filed
Yeah.
and seeing more of these come out. I mean, you kind of raised it. I think there may be a dynamic that like hospitals, medical has gotten the memo a little bit more. These financial institutions maybe don't understand as much. Do you think like when we're looking at the defendants and seeing them progress civilly, like improve their processes and practices, the health industry is maybe farther along?
I don't I don't know if I'd say that the health industry is farther along. I think the health industry has sort of they there have been so many lawsuits filed that it's almost like the basket's sort of like the well's running dry there.
Mm.
I wouldn't say honestly that like I wouldn't say I've seen such a major improvement in the healthcare industry so much as either you've been sued or you haven't yet been sued and you're on your way. The financial industry, because it's a heavier lift technologically and legally, there's more there, but the cases are often harder to create, harder to get to, harder to find, harder to file. So I think that's one of the reasons why it's sort of this emerging trend and hasn't been explored in the way that HIPAA or other like medical wiretaps have been in the past.
Yeah. I mean, there are definitely cases out there. I mean, there was a big Capital One case, and there have been a number filed against mortgage processors.
Yeah.
But I think what we're seeing is a real like takeoff in the volume. Like this is not, there's nothing necessarily new about using federal wiretap or GLBA or, that's been around for a few years, I think. But the courts are now really grappling with this. And, I'm aware of like there was a big tax act settlement for a vendor who was doing tax processing, very similar idea. And, there's a big meta case about tax filing. So this has been, but I do see, and I think we agree that there's like only going to be more of this.
I agree. I think it's definitely an emerging space. And the further, I think with experience, we get a lot better. We know what we're looking for. We know what creates a strong violation, a severe violation that courts will accept and understand as a severe violation. So as we continue our work, I think we're getting a lot better at finding exactly what the right case is.
Yeah, and I think that's across these ECPA cases and this Article 3 jurisprudence. I think the tracking, surveillance, like it's not necessarily, it doesn't need to follow a data breach model, right? It's like your browsing history, your surveillance, your all your activities across the website are being monitored, about across the internet are being monitored, and that like is a violation of people's privacy when they're not doing it without consent.
In the
Um,
same vein as medical is, right? You've got medical wiretap and medical data breach, and those are two separate things.
Exactly. And I think especially like some courts are more mature on this than others, but it's I do see there's like people are coalescing around this theory of privacy harm that is strong and is more realistic to the kind of what's happening in the commercial, ad tech space. So there's being a real kind of catch up, and financial is going to be a part of this. So I think maybe now turn to a couple questions. um, the first one, I think I see that actually may be better for me, which is what do we think about, settlement some amounts in this space? So, correct me if you've seen anything different, but I kind of have seen, there have been settlements against insurance providers and tax preparers, but it's still pretty early for this exact type of kind of, pixel finance data case
Mhm.
situation. I would imagine, like my guess would be, it would follow a similar trend to the health cases in terms of like the general order of magnitudes. You're dealing with similar statutory damages, similar kind of fact patterns, and it'll be a real question of whether the financial data is considered like more valuable, less valuable, and so a lot of things are in the motion to dismiss stage right now. But I think we'll see a lot more of this later in the year, and we'll start to get our arms around, how big these can be. Um, so I don't know if there's anything else you think on kind of the settlement front.
No, I agree with you. And then I see a second question we're getting is, have we seen any barriers around the sensitivity of financial data in these types of cases? And I think, tell me what you think, but I think we sort of touched on this before, that there's sort of a question around the narrative of GLBA as opposed to data breach information. But I think, I guess in a similar vein as medical, right? There's certain things that we personally don't think are quite up to the level of what would create a severe privacy violation. So in financial cases, that might be calculators. We didn't really touch on this before, but I think it's interesting to bring up now that a lot of times these websites will have calculators, calculate your mortgage, how much do you need to retire at age 60, whatever it is. And then you can put in all this information, and sometimes that's transmitted. But the information that you put in there is not necessarily real information, right? You can just be making things up. And so that might not reach the same level of sort of severe information violation as when I'm filling out a form for a mortgage, where the chance that the information that I'm putting in is real is going to be much higher. So my credit score there, I'm not likely to just put in, my credit score is perfect, my credit score is poor, if it isn't. So that, I think, is an example of where we see a sort of differentiation in financial data.
No, that's a great point, and it's very actually I'd say that's pretty similar to some of the medical wiretap spaces where cases where you may have an issue of, well, someone could just be researching for nothing to do with their own health information. In the California context, that may still be enough in terms of it was a wiretap, but that probably wouldn't trigger some of the other like HIPAA, for example, if it's not actually medical information, it's just research. And I think like a calculator, sort of a static calculator on a tool on a website that's publicly facing, versus where I think the strongest claims here are you are actually seeking, and the GLBA sort of contemplates this, you are seeking financial services, you are seeking a loan, debt consolidation. And to do that, you have to reveal things about yourself that you just wouldn't want to be public, like your amount of debt, why you are in debt, your assets, your credit cards, your, job and
Business
income and things like that.
history. Yeah.
Yeah, and I think in those cases, that you can understand just common sense the privacy harm there, even without having, like in the data breach context, a social security number, account numbers, things like that. Which if you had those in the wiretap context, I mean that's a really strong case, and I think we do see some areas where people are being asked for social security numbers. But yeah, so I think there's still going to be some development here, as you kind of alluded to, of what is enough. But in all cases, there's tracking and profiling and your browser history. Um, so I think we're kind of at time for today. So I'll thank everyone for listening. I hope you found it interesting. Please reach out to us if you'd like to talk more about these things or work with Darrow. We have an email here at contact@darrow.ai, but also you can find us and reach out to us as well. And I thank everyone for your time, and thank you, Diana. This was really
Thank
fun.
you. It's great seeing you.